There are several questions in the community when it comes to the law, especially with the immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon and I am your host. Hello, lovely people. It's so exciting to come your way a Saturday afternoon to bring you The Community and the Law live on BWTV UK and brought to you by BWF Solicitors. It's a very wet, cold, chilly Saturday afternoon here in the UK. But whatever it is, there's some excitement in the air because we are going to empower ourselves with knowledge and, of course, get the experience to be able to live on the right-hand side of the law. My name is Oreku Frimpon and welcome to another edition of The Community and the Law. This afternoon, we're looking at the new UK government's proposals on immigration, and we're going to find out what it means to you. There are the proposals. There are the things that we don't understand. And there are explanations that we can get in waiting for them to take place or even happen here in the UK. BWF Solicitors is giving us the opportunity to discuss this. And our friend, lawyer friend, and guest, as usual, will be lawyer Charles Asma on the program. It's a community and the law, as I said. Welcome on board and let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live. This is another edition of the Community and the Law, brought to you live on BWTV and by BWF Solicitors. We're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. My name is Oreku Frimpon. Welcome to the show. This afternoon, we're going to look at a very important topic. During the week, we heard that in the Parliament of the UK, there have been proposals put forward, and it's going to go through consultation. And then, when it is decided by the 6th of April 2026, or April 2026, so to speak, it may become law. The new UK government proposals on immigration is what we are talking about. And this afternoon, we're going to look at what it means to you and how you can navigate your way around it, within it, and with it. Once again, my name is Oreku Frimpon, and I have the honor of hosting lawyer Charles Asma from the stables of BWF Solicitors. Lawyer Charles Asma has always been available to help us through these things, and today he is going to help us understand what these proposals are and what they mean to us. But before then, let me acknowledge those of you who have had a chance to join us live on Facebook and YouTube. And on YouTube, I can see my sister Joyce Sawa. Good afternoon to you. Thank you very much. You say hi. I respond and also say hi back to you, wave back at you. Those of you on Facebook as well, Eric Kojo Asante. Yes, I can see you, Eric. Thank you very much for joining us. We also have on board those of you who are calling Tilly Duman, Nana Jiman, and all the people calling people to come to the classroom. Yes, we acknowledge you. We thank you so very much. Now, saying thank you, we have people who have also actually Kojutufu is here. You're in Hammersmith. Oh wow! How's the weather? I hope it's okay. And whatever it is, you have wrapped up yourself warm so you don't get cold. I am going to acknowledge one thing, or some of the sentiments that people have expressed using the services of BWF solicitors. And I start off with M. Darko. M. Darko is saying that so grateful to BWF solicitors for helping them with their spouse visa case. From the very beginning, they were professional, knowledgeable, and genuinely cared about their situation. The team guided them through every step of the process. From gathering documents, their attention to detail and clear communication made a stressful situation so much easier to manage. Thanks to their hard work and expertise, the spouse visa was approved and they can finally be with their partner. and they highly recommend BWF Solicitors to anyone looking for reliable and compassionate immigration support. Thank you again for making it possible. M. Darko, thank you also for helping us to share your sentiments and also helping us to know what we can get from BWF Solicitors. So those of you who haven't had a chance to visit BWF Solicitors or even use their services before, they are on the 4th floor of the Anna House, 214-218 Tottenham High Road, 7 Sisters in North London. They work Monday to Friday between 9 a.m. in the morning and 6 p.m. in the evening. Call them on 0208 493 7340. I say the number again, 0208 493 7340. Or you can call 04477 127 884. For that, you can send a text, WhatsApp, or even do a voice note. And in all emergency situations, that is your number. So BWF Solicitors, as M. Darko said, we salute you. We thank you so very much for doing what you do for us all the time. And we appreciate you as well. And we also appreciate the fact that you give us this opportunity every Saturday afternoon on the community and the law. What's new? Anyway, let me quickly go through some of the things that we let you in on in the week. A nugget, for instance, is one thing I want to really put to you right now. So from 1st of May 2026, it will be an offense for a landlord or letting agent not to allow an individual to enter a tenancy agreement because the person claims benefit. This is from Section 34(1)(a) IV of the Renters' Right Act of 2025. From the 1st of May 2026, it will be an offense for a landlord or letting agent not to allow an individual to enter a tenancy agreement because the person claims benefit. Now, with that, let me go to do some housekeeping and invite and welcome on board a resource person and guest this afternoon, Lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Brother Cook.
How are you doing?
Very well. How are you?
I'm very well. It's just cold. If I here in the UK, I haven't seen anybody quite comfortable when it is cold. But yeah, that's what it is. It's November, so obviously the weather is quite.
It's a winter month, and I mean activities have taken us to Berkshire. So I'm currently in Berkshire region, but we still have to be available for the community for the love of the show.
Well, obviously, you can't stay at one place. The community needs you, and the community is wide and spread out. So definitely, yeah, we understand. But we're so grateful that you have had the chance to really come on board and help us, as you said, for the love of the community, for the love of the show, and also for us to be able to reach out to the community as we do. Now, it's said that from the 1st of May 2026, it will be an offense for a landlord or letting agent not to allow an individual to enter a tenancy agreement because the person claims benefit. Does it mean that if you claim benefits, you can't go into renting a property? Is that what it says? And why is it changing?
Right. So the Renters' Rights Act 2025 is coming into force from the 1st of May 2026. What's the context? You know that there are a lot of issues within the housing space as far as renting or rentals are concerned. And most landlords and estate agents tend to have upper hand, and to the extent that most people appear to experience discrimination or unfair advantage, are disadvantaged. Some of these people are people with children, people with pets, and so on and so forth. Most landlords will tell you that if you have a child, no, they will specify the sort of tenant they prefer, and these appear discriminatory. And so the government, after consultation through Parliament, has concluded that the law, the Renters' Rights Act 2025, is come into force. It's already received the royal accent. It's received royal accent. And so we are
Well, viewers and I guess Lawyer Asma is, as he said, he's out and about, so sometimes the network may fail us. But he was explaining what is coming into force. The Renters' Right Act of 2025 has received royal assent, which means that it's going through Parliament, it's going through consultation, and it's been passed. And of course, the King has put his signature to it, so it becomes law. Um, I think we've got Lawyer Asma back on there. Let's see to get him back for him to give us a bit more detail into that. Lawyer Asma.
so, as I was saying, the law is now clear that from 1st of May 2026, a landlord cannot propose that because somebody has specific characteristics
Mm-hmm.
or somebody can be described in one way or the other, the person cannot enter into tenancy agreement. And so if you look at section 34, it's clear that from the 1st of May 2026, it would be an offense for a landlord to say that because of A, B, or C about you, I cannot enter into a tenancy agreement with you. And that is good news for those of us who depend on others to be able to have a home to stay as far as renting is concerned. And so the piece of news is that if you are somebody with children, whether a single mom or whatever it is, or with your family, it doesn't really matter. A tenant, estate agent, or a landlord cannot say that, oh, we've entered into the agreement. However, we now realize that you have children, and so we cannot proceed. It's an offense.
Well, then I would want to put the scenario before people. I won't ask Lawyer Asma to answer it now, but let me put it before you. So, if we have the scenario in front of us, there's our friend Cecilia who lives with her two children. Her current tenancy expires in June 2026. She recently has access to public funding, receiving a universal credit of 2,400 per calendar month. Her landlord has assured her previously that she could continue the tenancy if she prefers, for which she has agreed in principle. Yesterday, her landlord told her that she must be aware that the tenancy cannot be renewed if she starts receiving benefits. She's now so worried that she cannot renew the agreement in June 2026 as the landlord has earlier assured. So, based on this, let's advise Cecilia. Could it be that Cecilia should start looking for alternative property to rent because she has no option? Can we tell her that Cecilia, you should go beg the landlord to allow you to continue the tenancy agreement in June 2026? Otherwise, she may be homeless. Could we also say Cecilia should not worry about what the landlord is saying because being on benefit cannot be an excuse for the landlord not to renew the tenancy for her? Think through this. I will be coming back to you later on in the program for us to really look at that. Um, Somebody being homeless because the tenancy has expired and because of her situation, receiving benefits, she cannot. Um, Renew that because the landlord says, "Nah, you undo." So then you cannot rent my place. Is that allowed? What is the Tenancy Renters Act of 2025 saying? Think through that. We'll come back to you. But Layasma, let me come back to you quickly whilst we put this aside. Come back to you quickly and say that um, there are a lot of changes coming when we talk about immigration matters. Um, Apart from the new proposals about um, the one we're going to discuss, let me put it that way. Are there any other new things that have really popped up their head?
Right. I mean, at the moment, what is making the news is
Hmm.
the proposal, and
Okay.
anything else is covered by the proposal itself.
Okay.
So, anything else we say will be swallowed by the content and the impact of the proposal. So let's focus on the proposal for now, and all other things shall be added.
Yes, so seek ye first the proposals, and all questions will be answered. I'd like to say thank you very much for joining us. Tilly Duma, you on board, Kofi Nat, Penelope Pinzo, and Ezekiel Johnson, Margaret Adumensa, Gia Dina, Ernest Anini, Zena Small, anyone to answer general questions without commitment. Zenas, I don't know what you want to talk about. But whatever it is, if there's a question, Loyansma will be gracious enough to lead us on with a good answer. So let's know if you are here. Let me see you. Drop me something in the comments down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. BWF Solicitors, they help us with opportunities like this. They help us to put through immigration applications. They help us with family. They help us with business advice. They help us to look through things and signpost as to where we need to go when it comes to getting the property, business support, and all the rest of it. BWF Solicitors, 0208 493 7340 and 077127 Those of you in Ghana, there's an office, and the number is 055 589 5959. We say thank you to them, and when we're back, we delve straight into the discussion. Lawyer Charles Asma is going to help us understand the proposals that have been put forward as far as immigration is concerned, when they will take place, why should they take place, and how we can navigate around it. How it affects you, we'll be discussing that right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration analysis, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
the video. Welcome back, and we are going to have a discussion on the immigration proposals, as lawyer Asma has mentioned. And he's saying that he doesn't want to drink the soup before we get into the main meal. So we'll be looking at that. But the UK government proposals on immigration, what did the Home Secretary Shabina, or Shabana, so to speak, Shabana Mahmood say? Let's hear this briefly, and I'll get lawyer Charles Asma to take us through it.
I can't hear. Can you hear? Hello?
I think we're having some challenge with the sound of that, so we'll come back to it in a moment. We were trying to bring you the bit about what the Home Secretary said earlier on in the week. Let's see if we can really bring it back. Let's try it again. Let's try it again and see if we can get a sound for it to happen so we can have something for this country. Let's try it again.
It's still the same. I'm not sure why.
To settle in this country forever is not a right, but a privilege, and it must be earned. The starting point for settlement will move from 5 years to 10. To ensure this is earned, new criteria will be added, which will act as a disqualifying bar for those who do not meet them. Firstly, the applicant must have a clean criminal record. Secondly, they must speak English to A-level standard. Thirdly, they must have made sustained national insurance contributions. And finally, they must have no debt in this country. While these criteria set the bar that everyone must meet, there are a series of other tests that have today been published for consultation, and these either add or subtract from the 10-year qualifying period. To recognise the particular value to society they play, the government proposes the following. Those who speak English to a degree level standard could qualify for a 9-year path to settlement. Those paying the higher rate of tax could qualify at 5 years, while those on the top rate could qualify after 3, the same as those on global talent visas. Those who work in a public service, including doctors, teachers, nurses, would qualify after 5 years, while those who volunteer, subject to this consultation, could qualify at between 5 and 7 years. I love this country, which opened its arms to my parents around 50 years ago, but I am concerned by the division I see now, fueled by a pace and scale of change that is placing immense pressure on local communities. For those who believe that migration is part of modern Britain's story and should always continue to be, we must prove that it can still work, that those who come here contribute, play their part, and enrich our national life.
Well, that was the Home Secretary, and sorry for the sound that was failing us earlier on. I want to also acknowledge that we had a feed from Sky UK, and we want to acknowledge and appreciate that for all of you. Lasma, yes, that is a preview or a prelude to what we're going to discuss. There have been proposals sent in. We've heard over and again the word consultation, and the rest of it. Now, before we go into the details, can I ask from you, and you always helping us, when we say proposals and them going through consultation, what are we talking about?
Right. So, as far as we are aware, this is a proposal.
Mhm.
It's a proposal because the government is planning to do something.
Right.
We are not there yet. What the government will actually do. It might be that the government will water down the actual plan or execute the entire plan. But
Okay.
either way, what the government is saying is that something will happen. But before that, we want to be a listening government and listen to what people feel and think about this plan.
Mhm.
Depending on the level of feeling and concern, it might be that something may be done about it. The plan will not change completely, but it may be watered down to an extent. And so everybody must get involved in terms of adding your voice. The more people speak about this to express concern, the better it is for everybody in terms of what the government may end up doing. It's
Okay.
not going to happen that nothing will happen. Something will definitely happen. However, we want to make sure that it is not severe and detrimental to well-being of an immigrant as far as settlement in the UK is concerned. So that is the point here. So the consultation has started and the government intends for it to end in February 2026. That means from March, April, after the consultation, it is likely that things will be rolled out. And once they are rolled out, they become law. So let's all get involved. How do you get involved? Go online, and in the course of the session, um, Bregwick will get the link, the survey,
Okay.
so that we'll share it for people to access through the chat box and get involved because there are questions to be answered. And the answers will determine whether government will feel that the public is not entirely happy and if something could be done about it. It is not fair, for example, for somebody to wait forever in court for them to settle, having had expectations. But we are going to go through to look at if this becomes rule or law, what the impact will be for about 80% of immigrants who have not yet settled in the UK.
So these are new proposals that have been put in place, and as you have explained, if I got it, the consultation is where people would have to put their ideas out, their opinions out, what they feel about the proposals out, and maybe get a few things within the proposals change before they become law in April 2026. Is that what is going to happen?
Yes. Yes. So we have to make sure that we all get involved Without the consultation, the government cannot proceed because there's what we call public impact assessment. And that is what the government is started doing. The government is going through the public impact assessment. And this assessment will determine whether the impact will be severe or not. And if people are saying that it's good, but the impact is not going to support the need for this policy, then the government may do something. Who knows? But whether the government will do something or not, we all have to get involved because we have our opportunity to speak up.
Now, so speaking up, we say we don't want what's going to happen, though we're going to go into those details, so I wouldn't pick them up now. But we would say you have proposed 1, 2, 3, 4, 5. All 5 are not good for us. So does it mean that the more people speak against those proposals, the less likely that they will happen? Or it will happen no matter what because the government has the power to do it?
So we know that either way it will happen. But if it's going to happen, how much of it should happen to us? Because each of the proposal has impact, and the assessment is about the impact. It may happen and the impact is good. Everybody is happy. It happens, the impact is not so good. Then people are upset about the policy. So as part of the tick box exercise, the government is saying that I want to hear from the public. Assuming everybody is saying that no, immigrants contribute so much to the socioeconomic development of the nation. And so this is going to cut off the support or the contributions. Then it may be that instead of 15 years, for example, they may bring it down to, let's say, 10 years as it stands. Or it may be that, yes, you don't have to receive benefit, but depending on your circumstance, if you receive benefit, we'll pardon you. That is the assessment, the impact assessment period. And because they will have to then convert all the responses into impact test to see what will be the level of impact on growth, on development, on regional integration, and everything else, and on the balance of probabilities, whether this impact should be rolled out, this policy should be rolled out gradually or should be implemented fully and once. So all this will be determined by the survey and what people will be saying. Imagine nobody complains about it. That means the government is happy that people are happy. But if a lot of people, if about 50% of the population or the immigrant population are complaining, then that is something for the government to consider.
Right. So as members of the public will have the opportunity to say something about that. I know definitely you're going to tell us how we can participate, how we can be part of the consultation. But let's see, what are the changes? What is changing? Why should we even worry about it at all?
Right. A lot of things are actually changing. A lot of things are actually changing because we are looking at what stands now and what is yet to come. As BWF solicitors, as community lawyers, we've already come up with flyers to let the public know. So what we're going to do is you are going to read through some of the pointers, the key points, after which we'll discuss and we'll drill it down into specific details. So Brakoku, this is for you.
Okay, so as you said, BWF Solicitors is kind of summarized it and put it in a form that will make it quite easy for you to read and understand. And the introduction is UK government announces consultation for end settlement reforms. End settlement reforms. What is in there? So let's get into it and look at the announcement that was made. The government has published a policy statement outlining its proposed substantial restructuring of the framework for obtaining settlement in the UK, which the state aims to make permanent resident contingent upon compliance, integration, and a measurable contribution to national life. The 60-page statement presented to Parliament on the 20th of November 2025 outlines the details of a consultation on proposals to reform the current settlement rules in favor of an end settlement model. End settlement model. So, how would the new settlement model work? And we'll go through that. It would move from the existing 5-year standard qualification period to a default 10-year qualifying period for most migrants based on the following, which have been outlined. One, character. Applicants must have a clean criminal record and no history of immigration non-compliance. 2, integration. Applicants must demonstrate meaningful engagement with British society, including meeting a higher English language requirement of B2 level and passing the Life in the UK test. 3, contribution. Settlement will depend on sustained economic participation. Applicants must have annual earnings above 12,570 for at least 3 to 5 years. Higher earners may qualify sooner. Those earning above 50,270 for 3 consecutive years may be eligible in 5 years, whilst those earning above 125,140 pounds in 3 years. And there's a fourth one, resident. Continuous lawful resident remains necessary, though residence alone will not confer eligibility. Can we scroll it up because there's a further one there? Will not confer eligibility on that person. I'll continue to read, and the next one talks about what the other proposed adjustments for standard qualifying period are. And we know that the proposals are saying that applicants' qualifying periods may be increased or reduced according to set criteria. In addition to the earnings criteria mentioned, as I read earlier on, other deductions include 5 reductions for partners, parents, children of British citizens and British nationals who are overseas, and for certain public service workers. Up to 7-year reductions for global talent and innovator founder visa holders who have resided continuously for 3 years, and 3 to 5 years for significant community volunteering. Up to 20 years for applicants who entered illegally, overstayed their visa for 6 months or more, or entered on a visit visa. This would mean that where a person could have a 30-year wait for settlement. 30 years. Whoa, that's a lot. Well, access to public funds and citizenship. The statement, as read and proposed, says and also raises the question of whether access to benefits should be deferred until British citizenship is obtained by introducing a no recourse to public funds condition on settlement. The government's rationale is to align settlements more closely with what it terms contribution and fiscal sustainability. The consultation also anticipates reforms to the British Nationality Act of 1981 so that qualifying periods for citizenship will reflect similar principles of earned progression. Long residence to be abolished. In another significant development, the long residence route would be abolished and subsumed within the new end settlement model. We go on and it says, I don't know whether that ends that bit. Okay, Charles, let me bring you back in because I've read a lot and some people may be confused and lost. So let's go to the very beginning, what the proposals say are coming. So the end settlement. That's significant. That expression there, end settlement. What is it talking about, lawyer?
Okay. So at the moment, we know that settlement is automatic or assumed. Assumed settlement means that if you're able to do X number of years, you are able to get your citizenship, your settlement. So if you're on the 5-year route, for example, you know that after 5 years you can get settlement. If you are on the 10-year route, you know that after 10 years you get settlement. So these are automatic, and therefore the key factor here is long residence, isn't it? So all you have to do is to wait patiently, and you know that if you can wait, you can get it. What's happening now is that it's not about wait any longer. It's about other factors in addition to waiting. So somebody can wait up to the limit and yet they don't get anything because they haven't added anything or brought value to the economy. So it's about impact, it's about contribution, it's about assessment of what makes you, why should we consider you to give you settlement? What do you bring to the table? What do you add? So there's value addition. So instead of waiting for 10 years, it is no longer going to happen. 5 years, it's no longer going to happen automatically. And so time as a factor alone is not a basis for settlement. What other factors? So we have watched the clip. Those of us who listen to the news in the course of the period on Thursday 20th, we were clear that the government has something up its sleeve, and it came out strongly. And the command paper is clear that the data show that a lot of people who gain settlement go on to benefit. A lot of people who are already on benefit are also moving on, and so many other routes, all gearing towards settlement. So the government, after reviewing all this data, concluded that we have to find a way to manage or control the process so that it is targeted and doesn't become automatic. What is automatic? Where you know that it's clear that after this period, I am done. So at the moment, once it is changed, it's no longer going to be that after this period, I'm done. You have to add other things. So let's now focus on those who are not affected. Then we'll then discuss those who are affected and what they can do. So we have EU, for example. Under the withdrawal agreement of 2020, the law is clear that EU nationals should not be disadvantaged in any way, shape, or form, regardless of any change within the UK as far as rules are concerned. And this is a change that is going to happen or may happen. Should this affect the rights of EU citizens or nationals and their family members, that will contravene the withdrawal agreement of 2020. And so the Secretary of State was clear that EU nationals and their family members who are on the 5-year route, that is pre-settled status, are not affected.
Yeah.
So if you are a EU national or family member of an EU national and you have your pre-settled, you are still able to calculate your time. 5 years, you can apply for indefinite or settled status if you still meet the rules. So that's fine. What about British citizens who are married and are living with their spouses in the UK with the expectation that after 5 years they will be able to settle and move on? Are they also affected? The government is also clear that those people are also not going to be disadvantaged. And so British nationals are also, spouses of British nationals are also spared. What about children of those British nationals? Yes, they will also be spared. However, it's clear that the government may look at a way to approach settlement for those children who have attained beyond age 18 or who have attained 20, or let's say who are above age 18. And those above age 18, depending on how old the child is, may not necessarily depend on the parent to acquire settlement. So that is also something. So the government is going to have a separate pathway for those children. Again, spouses or dependents will not be tagged along their main sponsors, especially those in the skilled work sector. They will not be tagged along automatically. So there's going to be another pathway for dependents. So if the main applicant is doing well and the dependent is not doing much, then they are going to have a split. You can go and they will have to make their way to settlement. So these are things that are coming up. So we have touched on those who are not going to be affected. At the moment, it's not quite clear that somebody who is a spouse of a settled person, somebody with indefinite leave to remain. If you have indefinite leave to remain, you are not a British citizen yet. What if you are, for such a person, or again, they have 5 years, but are they also going to be treated the same way as people who are British nationals or British citizen spouses? It's not quite clear. We'll come back to you later on once the details are clearer. But for now, this is where we are. After commercial break, we are going to look at the fine details in terms of those who are affected and what they can do to shorten the time, and what can be done, and what they can also do to increase the time. So even though you can shorten the time, you can also increase the time if you are not careful.
Even though you can shorten the time, you can increase the time if you are not careful. And we're going to have a look at those who are affected, those who do not need to bother. And of course, we will go to the next step of going through in fact, the consultation document where we can participate in the survey and all that. And it's all live on the Community and the Law, live on BWTV, at Facebook, at BWF Solicitors on Facebook and YouTube, I should say. BWF Solicitors, thank you. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we're still live on the Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we're looking at the proposed immigration changes that should take effect from April 2026. They are proposals at the moment, and consultations are ongoing. Who is affected? Who is not? Lawyer Charles Asma is a resource person and guest from BWF Solicitors. We live on Facebook and on YouTube at BWF Solicitors and BWTV UK. I have the page where we can go on and answer the questions and also participate in the consultation. You can see it on the screen now. The Home Office started with that and is going to be live until February 2026. So as I have highlighted, the consultation survey will remain open until 23:59 on the 12th of February 2026. Now, the survey should take approximately 20 to 30 minutes to complete. For somebody who is quite busy, you might think that, well, there's a long time, 30 minutes of my time, but listen, it will affect you in the long run. So please, 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 please take time and go to the page and, of course, answer the survey questions. We will put the link in the comment section on Facebook and YouTube. And those of you who would want to have it, you can request from Home Office to send you a copy, or you can go online, as we have put the link in the comment section down below to do it. So if you look at my page, for instance, you see that I'm clicking on the arrow pointing to your right, and it takes you to the next page, and it asks you whether you are an individual responding to this survey or an organization. So a church could organize and answer this. An individual like yourself, myself, could get yourself to sit through it, and then it asks you well, your immigration, your citizenship status in the UK, and all the rest of it. But yes, we will come back to it. But I'm going back to Lawyer Charles Asma to really continue with the discussion. Before we left for the break, he was talking about who will be affected, how it will affect you, and then we'll come back to this and see how we can quickly run through it and see how you can answer some of these things. Lawyer Asma.
Thank you very much. Yes, so we are going to go through and then we bring the table that shows specifics for people. So the first thing is that if you are in the UK and have not already settled or attained indefinite leave to remain status, this policy may affect you.
Mm-hmm.
The module is contribution. So contribution-based module to settlement. And here there are three key themes. The themes, I call it BIC, behavior, integration, and contribution. These are the three themes. Under each theme, you will see that it's expanded to cover specific factors. So under behavior, you are looking at how good or bad you are in the in the UK as far as your life is concerned. And here we are looking at criminality and other unlawful behavior. So if you are someone who is being involved in unlawful behaviors, then that will take you longer because your behavior is not conducive to the public good. We're also looking at integration, how good you have integrated into the British society. And this is where volunteerism comes in. That is where speaking of English and English language proficiency comes in. Understanding the culture, the British values, the value of democracy, the value of citizenship, the value of teamwork, the value of care and support, and so on and so forth. So British value has been integrated into this module so that if you are somebody who is able to bring a lot to the table in addition to your personal life, then that will give you points. So integration, English language is part of integration. Your understanding of culture is part of integration. How much you volunteer in the community is part of integration. And so that is integration aspect. Again, part of integration, we are looking at what your work does for the community. And so here, those who are into public services, healthcare, education, and so on and so forth. So teachers, doctors, nurses, and what have you, they all bring a lot to the table. And so such professionals will be given credit for their contribution. Then we come to the third theme, which is general contribution. In general contribution here, we are looking at, in addition to the volunteerism, we are also looking at financial contribution. You work, but how much do you bring to the table in terms of tax and NI? So the more you bring, the more points you score. The more you bring, the more points you score. So remember, the module is built around 3 key themes: behavior, integration, and contribution. Financial contribution and non-financial contribution.
Okay.
So somebody may say, but if I'm not working and bringing a lot, can I do something else to contribute? Yes, that is volunteerism. Okay. Somebody may say, okay, I have to upskill myself to English language. What sort of level of English? Up to B2, A-level English level standard. So A-level English is B2. We know that below A levels is B1, that is up to GCSE level. Then we have we have A1, and we have A2, and so on and so forth. But what they are saying is that you have to have up to A-level standard. Again, in terms of the role you play, the job you do, all jobs that are below degree level are really not going to add value in terms of financial contribution. So in terms of financial contribution, we are looking at the tax you pay. And we know that we have the minimum and the maximum and the mid-range. So the median salary is about 50,270 pounds. 50,270 pounds. That's the medium salary. The lower part is about 12,571, because below 12,571, you don't pay tax. So if your salary is just 12,570, that is the personal allowance where you don't pay tax at all. Therefore, to be able to pay tax, you have to earn more than 12,570, and that is the £1 difference and above. So we have the lower range, mid-range, and the upper range. Upper range are those people who pay the maximum tax. The maximum tax we know is 45%, and those who pay above that are contributing so much. Those who pay, so we have 30%, we have 20%, and so on and so forth. But those who are paying 45% and above are those who are earning so much. And we are looking at about £125,140 a year. So if somebody is earning £125,140 a year and more, that is a higher tax earner. And such higher tax earners automatically will be paying more. Somebody spoke to me yesterday and said that, please, let me pick your brain on this. The person is a high tax rate earner, earning £150,000. It's a skilled worker working with the city firm. The person is able to mitigate the tax liability through pensions. You know that there's tax mitigation, which is lawful. So you can channel your tax into your pensions for future. You know that. So if I'm channeling my money into pensions so that I'm able to reduce my tax, am I contributing more tax or less tax? What do we say? Less tax, isn't it?
Less tax, yeah.
So somebody may be a high tax earner, yet is not contributing much. So when we work the maths, I told the person that it appears that you are not contributing much because you are channeling everything into your pensions, which is for yourself, not for the state. And so the person said, okay, that means I have to give up and pay it in terms of going forward. I said, yeah, it appears so, because that's the only way you can earn more points. So it means that if you are earning 12,570 and you are not contributing enough in terms of tax and national insurance contribution, you are likely to wait longer, because a lot of those people are either receiving government support, even though they are not receiving state support. The earning is such that the contribution to the treasury is not enough to earn them points. So what are the points you can score here? The points you can score under financial contribution are, if you are earning £125,140 a year, and you have been earning this and paying your tax consecutively for 3 years, you can shorten your settlement period to 3 years.
Okay.
So even if the person is on 5-year route and they've been contributing that much, they can save 2 years.
Okay.
Then what about those people who are within the median range, earning £50,270 a year and paying tax, because 50,270 is also a high tax rate earner. Those high tax rate earners, 50,000 and above, the person will be contributing to tax and national insurance. And here, the government is saying that if you're able to do that for 3 years, you can shorten your settlement by 5 down, so you can go for settlement at 5 years. What it means is, if the person is under 5-year route, skilled worker, and they are not contributing enough, that means they have to stay longer. So the more you contribute, the more you gain. That is what we call contribution-based or earning-based approach. Earning-based approach. Good. So you are showing the statistics. So we have the lower band, median, and the upper band. The upper band, you say you shorten it to 3 years. Median, you shorten it to 5 years, and lower, you stay for longer. And so 12,570 for at least 3 years. Higher is this, and so on and so forth. Obviously, if you are earning 12,570, that's not going to give you enough. And so, but it doesn't mean that people can force themselves to earn more. It is the market rate. And so, so what are they trying to say? They are trying to attract highly skilled professionals or retain highly skilled professionals. Do you agree?
Yeah, because obviously they will earn higher, and all these criteria of English, whatever, and all the rest of it, they would obtain those ones as well. So when it comes to the contribution, I think so.
So now let's break the criteria down. So English language proficiency at B2, A-level standard, you can reduce your 10-year wait by 1 year. So 9 years, you can apply for indefinite. I'll say it again. If you can speak and write English, listen, and your appreciation and proficiency of English language is up to somebody studying at A-level in the UK or college in the UK, that you can apply for indefinite at 9 years instead of 10 years. So what is the credit? 1 year, isn't it?
1 year.
1 year credit. Now let's come to, so you can see that B, English language is under integration, isn't it? How to integrate into their culture.
Yeah.
The language aspect. Then we come to contribution under tax. Tax 1, tax 2. So tax 1 is the mid-range and tax 2 is the upper range. So tax 1 contributors will be those earning 50,270 and above, and they can apply for indefinite leave to remain 5 years as a skilled worker.
Okay.
Then tax 2 are those £125,140 a year. Super upper. And the super upper earners, they can apply for indefinite leave to remain 3 years after contributing this for 3 years. So you have to show the, because it's not a case of saying, oh, I did it last year, tax year 2020, 23, 20, or 2024, 2025. And so I'm coming to apply for indefinite leave to remain in 2026 because I'm due. No, they have to check the trend for 3 years. And that is why my mate who works with Price Waterhouse, Canary Wharf, was asking me, so Charles, in this case, can I apply for this? I said, let's look at the trend. How many years have you contributed? She said that I was channeling most of my salary into my pensions, and it appears that contribution to tax is less. And I said, in that case, you cannot take advantage. Because even though you've contributed for 3 years, such contributions are minimal. You see the nuances.
Mm-hmm.
Right. So even though you are a high tax rate earner, it depends on how much you put into the tax pot, whether you are channeling it into something for yourself or you are really giving it to the government. The more you give, the more you get in terms of settlement period. Right. Now, let's come back to those who are lower, 12,570. Let's assume that you are working part-time, earning 12,570. Under the tax regime, 12,570 is a personal allowance. That does not attract tax. That means even though you are not paying tax, you are enjoying, you end up, so that enjoyment is going to translate into a longer waiting period. Do you get it?
Mm-hmm.
So it's like if you want it, then you have to wait longer. If you don't want it and you are going to give it up, then you have to get it in terms of settlement earlier.
So Lawyer, let me ask this question. You know, on the contribution side, and number 3 on our screen as we see it, settlement will depend on sustained economic participation. You have explained that. Applicants must have annual earnings above 12,570 for at least 3 to 5 years. So if I've been on the allowance level where I don't pay tax for 3 to 5 years, does it mean that I don't qualify because I will have to earn above the 12,570?
So this one, we have to go beyond the letter of the word and look at the spirit of the word.
Okay.
The writing there says that, what's the operative word there?
Must have.
Above. No,
above. Yes.
Above up to what? Does it give us the limit?
No, but it says above 12,570. So if I earn 12,600, I qualify.
No, well, it's so above. So we have to check how much above. From £1 after 12,570 up to 1 million.
Okay.
And that's why it says that for those people who are above the lower band, they can shorten it to 3 years or to 5 years. The 3 years are the mid people, 50,000. Now it is then. So from that sentence, they give us the description of who is who.
Okay.
So those above 12,570, such as 50,270, they can get it for 5 years if they have done it for 3 consecutive years. And those who are contributing above the 12,570 and exactly paying 125,140 pounds a year and have been contributing to tax for 3 years, they can get it for 3 years. That's why it says above for at least 3 to 5. So for the 3, we are looking at the upper. And for the 5, we are looking at the mid. So if you are just earning 12,570 and 571, which is above 12,000. Now, how much above are you there? £1, isn't it?
£1, yes.
£1 will not give you anything. That will give you the longer wait.
Oh, okay. Okay.
So now let's bring it down again. What is the difference between 12,570 and 50,270? What is the difference? Please, let's do the math. So we have 300 here, we have 38 there. So that is 38,300 pounds, isn't it?
Mm-hmm.
Yeah. So 38,300 pounds is above 12,570. So if you are getting more than 12,570 by 38,300, you can shorten your settlement by 5 years.
To 5 years.
Yeah. And what's the difference between 12,570 and 125,140? So again, we do the maths. once we please do the quick maths.
That's about 70,000 and over.
So 70. So if you are getting 70,000 and over, above what the normal people are getting, that means we are going to get so much from you, isn't it?
Yeah.
And so we give you higher credit. That is the definition of that.
Shorten it to 3 years.
That's the interpretation of above 12,570. And the breakdown is 50, 270, 125, 140.
Okay. Well, we have seen that you have to have a good character. You need to be integrated into the community where you can function very well, and they expect you to function at a higher level, B2. Your contribution would help you reduce it between 5 and 3 years. And then the fourth one, Laura, it says lawful
Yes.
residence. Continuous lawful residence remains necessary, though resident alone will not confer eligibility. So you can't say that I've lived in the UK for 25 whatever years and you don't satisfy the other criteria point. You cannot automatically get in your settlement, isn't it?
Yes. So there's baseline and there is also the value added.
Right.
The baseline is your time in the UK, your residence.
Mm-hmm.
Prior to date, under the relevant paragraphs of the rules, continuous residence would have been 10 years for indefinite.
Yeah.
By saying that going forward, once the proposal is turned into law, staying longer is not enough. Because if you have stayed longer and you are useless to the society, then you might not have come in the first place.
Right.
So it's about usefulness, value added, contribution, and integration and behavior. And so, yes, it is good that you have to stay longer for us to know that you are here. So long residence is important. However, staying longer alone is not enough if your presence is not felt in any way.
Okay.
That is the explanation of that statement. Now let's go to the other two factors because we've tackled B2 for 9 years. We've tackled those earning 50,000, 270 and above, getting into indefinite at 5 years, and those who are earning 125, 140 and above getting indefinite after 3 years. What about those who are contributing in other kind? So we have contributing in cash. This is cash, isn't it?
Mm-hmm.
And contribution in kind. So let's look at the kind.
Okay, so we'll move on to the next one, and it's talking about what you can do as part of your contribution to the community.
In kind, good.
In kind. So the other proposed adjustments for the standard qualifying period, I think this bit, Laura, I can quickly rush through it and say reductions for partners, children of British citizens, and those overseas for certain public service can reduce it to 5 years, up to 7-year reductions for global talent and innovator founder visa holders who have resided continuously for 3 years, and 3 to 5 years for significant community volunteering. I think that's the bit that you are trying to bring up. Is that it?
Yes, that's the point. So we know that those on the innovator program and also the global talent, they all gear toward community support and enhancement of quality of life, isn't it?
Mm-hmm.
Because somebody is globally talented. What they are doing is enhancing welfare, well-being, socioeconomic development of the country. So all those who are on global talent visa in the UK, what they are doing is bringing value to the UK. And those people, they remain 3 years. So that is the public service aspect, contribution. Mm-hmm. Again, public service aspect in terms of working in the service, public service industry or sector, teachers, nurses, social workers, doctors, and so on and so forth, whose contributions are directly felt by the public. So those front runners, so to speak. Then they can have indefinite leave to remain considered after 5 years of staying on that visa. Then we have.
Yeah,
should
so
we
it
go on?
says up to 20 years for applicants who entered illegally, overstayed their visa for 6 months or more, and all that. They will have to wait up to 30.
Yeah, we'll come to that. We haven't even tackled that yet, but we want to look at what the law says by contributions and integrations and all that. So we want to make it clear. Then we come to those who came, the specifics, the skilled workers, the care route, and all those ones. Those who came illegally, they got 10 years, 2.5, waiting for 10 years after waiting for 20 years and all that. What happens to those people? But let's quickly finalize it by the voluntarism aspect. So if you're able to volunteer, as we said, if you don't contribute in cash by tax and NI, contribute in kind with your skill, knowledge, and energy. In this case, you can volunteer if you are not a professional who is doing a professional job directly touching public service. You can also volunteer somehow. So imagine you have been volunteering every month in your community, helping this, doing that, and these things are recorded or logged, and somebody can vouch for you within the community. You know, some people get award by the king or now it's king. People get award by the king through their community contributions, isn't it?
Yeah.
So they are going to award points for those people who contribute directly to their communities. So this time it's not just going to be an award during the king's birthday, but an award towards your settlement. So for those people, they can shorten it to 5 years or 7 years, depending on how much they contribute in terms of volunteerism.
Okay.
Right. So these are the key aspect of the themes, the 3 themes. That means if your behavior is good, that is good. But beyond your behavior, you have to show your integration and your contribution. What about those whose behaviors are bad, that you can never get to settle? Let's say you are always flouting the rules, committing offenses, and here and there, you would never get to settle. Because what they are saying that criminal activities will prevent you from settling in the UK. Again, if you owe money in the UK, it says debt in the UK. What is debt in the UK? We say that what if I don't have CCJ, but I owe money? Yeah, you may not have CCJ, but it may be that you are owing money and your name is flagged. And I'm sure once this proposal comes into being, in terms of rules and laws, they will have a database to check those who owe money to banks and government agencies. Because they are saying that owing debt in the UK is going to be a factor, isn't it?
Yeah.
Yes. So now let's go to those who entered the UK illegally. Those who came as visitors, overstayed, and had children, got 2.5, stayed for 10 years, are on the 10-year route, waiting to have their indefinite. They are saying that those people can wait longer than they thought. What about those who came to the UK illegally? Obviously, remember we were talking about before, was about naturalization. If you enter the UK illegally, it's difficult to naturalize. But now they are saying that if you enter the UK illegally,
you can't even have settlement.
You may not even have settlement because you have to wait for 30 years. So imagine somebody came to the UK as a visitor, had a baby, applied for 2.5 under Appendix FM because they have a qualifying child under Section 117D of the Nationality Immigration Asylum Act of 2002, and they went on to apply for 2.5. They are going to wait for 10 years because they have to do it 4 times. All of a sudden, there's a new law in 2026 that you have to wait longer than 10 years. Then it will affect those people. Again, 30 years potential wait, isn't it?
Yeah.
But can that person shorten the time? Because the person came with a visitor's visa, it says this would mean that where a person what?
Could have a 30-year wait settlement. I think there must be something continuing on that.
Okay, all right, okay. So there are two clusters of people there. Those who came to the UK legally but overstayed,
Mm-hmm.
and those who came to the UK illegally and overstayed. Which one should have higher consequence or punishment?
Well, then, if you came illegally, obviously,
That's double sin, isn't it?
back in
You
the
came,
primary school, you say double
yeah,
punishment, DP.
you came illegally, which is first offense, and you have
Mhm.
overstayed, second offense. So such double offenders may wait for 30 years. What if you came legally, but you have overstayed? That is one offense within the spectrum, isn't it?
Mm-hmm.
But you'll be punished for overstaying. And it says that overstayed their visa for 6 months or more, or entered on a visit visa. This would be, so all those people will be, but
Could
again,
stay up to
you'll be
20
able
years.
to. So if the person want to shorten the timing, the 20 years or 30 years, if they want to mitigate it, what do they have to do? Let's go through the mathematics. If such a person, I came illegally, I'm waiting for 10 years to get to have my indefinite. I've got 2.5, 2.5, 2.5. There's a new law. You came illegally or you came as a visitor, you didn't go. Wait
Mm-hmm.
longer. But the law also says that if you do something, you can shorten it, isn't it?
Yeah.
So should a person will this person be saved by English language or tax or public service or volunteerism? Which one?
English language will reduce it by a year. Your
Okay.
tax could, depending on your level, could reduce it by
Very
about 3 years. Volunteering, you can cut it to between 3 to 5 years because you have contributed significantly to the community. And if you find yourself as a global talent, you could reduce it by 7 years.
But let's assume, let's be realist here. Let's be realist. What it means is if you came as a visitor, depending on your circumstance, you have 2.5. You are looking at you're looking after your child and blah 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 blah. It is less likely that you will be a global talent holder. True or false?
Yes, most likely. Yeah.
Yeah, so you can't even go close to global talent. So that's odd. Again, such a person may not even be literate enough. At best, B1 or A2. So English may be a hindrance. So we won't even go to English
Mm-hmm.
because that is
But
brain.
community service could help.
Very good, because that is energy, your time, and your skill.
Mm-hmm.
You see how it works out. So that is how we can mitigate some of these things. So visitors and illegal entrants are likely to shorten it through their volunteerism activities.
Okay.
And those who came with high earning potential, such as global talent, such as skilled workers, and so on and so forth. In addition to the volunteerism activities, they will contribute to tax, they will do this, they will do that, and then those people can even shorten it more. But because we are specifically looking at visitors and illegal entrants, we are saying that those people, even though it says 30 years, you still have a chance of shortening it by 5 or 7 years based on regular community activities.
Lawyer, I know there's a lot to this. There's so much to discuss, so much to explain. But we also stand the risk of overloading our brains with a lot of information. So we'll take another quick break. When we come back, I will be picking some of your questions. There will be some questions we'll throw at Lawyer Charles Asma to help us do that. But those of you on Facebook and YouTube, the link to the Home Office document is there. You can go on the .gov.uk and you look at the new immigration consultations and all the details about that. You can request a copy and they will send it to you, or you can download a PDF copy and go through the questions. I'll be going through some of the questions with you. Those of you who probably have downloaded it, we'll be starting from pages 44 upwards to look at that. Prior to that, there are the questions about who you are, your age, where you work, your nationality, and all the rest of it. But there are certain pertinent questions about the criteria areas. Your earnings, your English, transitional provisions, and all the rest of it. I will be helping you go through that with the help of lawyer Charles. I'll be going through that quickly. Somebody, Fizzy James, you say you have a question. Let's take our time and get through this. Even if we don't finish this week, we will continue next week to get into that because we have the consultation open until February 2026. Lawyer Asma, just hold your breath. I'll be right back. Ladies and gentlemen, we're doing this courtesy BWF Solicitors. Call them on 0208 493 7340. Or in emergency situation 077 127 61884. 077 127 61884. Or even in the situation, if you want to reach Lawyer Asma directly, you can call him on 07947 636037. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We're still live on the community and the law, live on BWTV at BWF Solicitors, both on Facebook and YouTube. We're looking at the new government proposals on immigration, and we're looking at how it affects you and what it means to you. We have lawyer Charles Asma from BWF Solicitors helping us through that. And he's taking his time to explain everything. I know you would be like, oh, there's a lot of that and the rest of it. No, listen, take your time. We will break it down as much as possible for you. Remember earlier on, I touched on the aspect of the Renters Act of 2025, and I had the question of dear friend, which I need to ask you to answer to that. But it says that from May 2026, it will be an offense for a landlord or letting agent not to allow an individual to enter into a tenancy agreement before the person, because the person claims benefit, as I mentioned. And Cecilia's case is what I was talking about. And I asked you whether you can profess some advice to Cecilia. She lives with her 2 children. Her current tenancy expires in June 2026. And recently, she has had access to public funds and is receiving 2,400 per calendar month. A landlord assured her that, well, whatever it is, 2026 in June, I will renew your tenancy. But then the landlord has come back to say, no, you claim benefits. So I am not going to get you to renew that, because anybody claiming benefits is not going to live in my house. Then she's worried. So then she comes to you for advice. Are you going to say, Cecilia, you should start looking for alternative property to rent because you have no option? Are you going to say to Cecilia that you should beg the landlord to allow you to continue the tenancy agreement in June 2026? Otherwise, you'll be homeless. And of course, are you also going to ask Cecilia not to worry about what the landlord is saying, because being on benefits cannot be an excuse for the landlord not to renew the tenancy for you? Think about that. We'll come back to it. But let me go back to Lawyer Charles Asma, who's graciously offered to explain these things, the new immigration proposals to us, and see if we can kind of do a summary of what we have had. I mentioned that if we're not able to exhaust it so very well, we can continue, because the consultation is open until February 2026. Lasma, let's get a snapshot of what you have taken us through today.
Right. So, yes, producer has graciously shared the summary with us. So, Brakoku, this is where you come in to tell us what the summaries are. And there are about how many of them? 16 of them. So, briefly.
Right, so I will whisk through them. Those of you who are watching us, you can take a screenshot of that and keep it, but you can also let us in. You can text or send a request through our WhatsApp number 0739920848. We can send this to you and put you as part of our distribution list. Well, settlement route, top rate of tax, so to speak. Yes to settlement, 3 years. Global talent, 3 years. British partner, 5 years. High rate of tax, 5 years. Public service, including doctors, nurses, and teachers, 5 years. And Windrush and EU settlement scheme hasn't changed. British overseas nationals from Hong Kong, 5 years. If you volunteer, yes to settlement could be between 5 and 7 years. If you speak English to degree standard or degree level standard, you reduce it by a year to 9 years. The new baseline arrived on safe and legal route. It is 10 years. Arrived or entered on post-Brexit health and social care visas, 15 years. I know many of our compatriots fall under this category. That's why we have highlighted it. Benefits received, less than 12 months, 15 years. Benefits received, more than 12 months, 20 years. Refugees on protected rights, 20 years. Arrived in the UK illegally, 30 years. Settlement rights for children, member of the armed forces, and victims of certain crimes. There's ongoing consultation on the cohort of interest. And all these, the conditions are clean criminal record, speak English to A-level standard, sustained national insurance contribution, and you have no debt in the UK. Lawyer.
Good. So you can see that in all this, there is what we call clean slate. Mm-hmm. When it comes to family law, when there is a post-divorce settlement matters, there's something called clean break. Are we going to go clean? Nobody will disturb anybody. For you not to be disturbed in any of these categories, so it doesn't matter whether you are contributing 1 million to tax or this, you have to make sure that you don't owe any debt in the UK. You have to make sure that you don't have any criminal offense. You have to make sure. So that is why it says that in all this, there is a condition. You can see that the condition covers everyone, right? Mm-hmm. So even though you have met the criteria and you are okay, there's also something to check. Watch your back. Are you clean still after all? Those are the conditions.
Right. Lawyer, with your permission, I know there are a few people with questions and contributions. We have somebody who is also patiently waiting on the line. I wanted to quickly go through the questionnaire and then come to the caller on the line. So my brother or friend who is on the line, please bear with me. Let's
And
see.
Brakoku,
Yes.
I know this is not our usual community engagement, because this is more or less emergency engagement, because everybody is worried.
Obviously.
So if we can offer a bit of time in addition to the standard 6 o'clock, so that we can tidy up the loose ends, because I know
Well,
by 6 we have to end, but just 10 minutes just to make
when
sure.
it's coming from you, I'm fine.
Okay, that's fine.
When it's
Because
coming
I
from
know,
you, I'm fine, because I'm
yes,
always worried about your time and your other
I agree.
engagement.
I mean, let's give community the best for today, beyond the best.
Right. Okay. So then let me whisk through the consultation and the document as a fairer pathway to settlement statement and accompanying consultation on end settlement. And you realize that it details all the bits that lawyer Asma has really talked about. So if you go to page 20, for instance, it talks about changes in family migration, changes in steady migration. It talks about the payments, the median annual adjustments, and all the other bits that he was talking about. They are all in the document. And you go to page 30, for instance, it talks about dependents and children. It talks about vulnerable groups. It talks about those in the armed forces and transitional arrangements. I want to quickly look at that. The consultation includes questions intended to seek respondents' views on how far the implementation of the end settlement model should be accompanied by transitional measures. The transitional arrangements refer to temporary measures, and we know that. So we'll go to that. So let's go to the questions and see what it is that we'll have to go through. So it talks about your background, as I mentioned. These ones are mandatory bits that you have to go through. But let's go to page 46, for instance. 46, for instance, starts with end settlement. And these are questions that we all need to really go through. Overall, how clear do you find the proposed changes to the settlement framework? What you are saying? Is it clear to you? You can answer very clear, whatever. But to me, I would say it's neither clear or unclear, maybe. But your answer. But there's this one. To what extent do you agree or disagree with the proposed changes to the settlement framework? Asma, can I say I strongly disagree?
Yes, because if you strongly disagree, then you have optimum dissatisfaction about the plan in entirety.
Okay.
Yes, because it's a to what extent, isn't it?
Yeah. Do you agree or disagree with the proposed changes to the settlement
Yes.
framework?
So obviously, I don't agree, and most people don't agree with this proposal. So
Okay.
strongly disagree.
Okay, that's the one at the bottom here. So yeah, and that's the end settlement. Then it comes to character. So then we're looking at, do you have any comments on how character should be considered and all that? Then goes on to ask all those questions. What do you think about the 1 year reduction for applications who can demonstrate advanced English language ability at C1 standard? Now they're saying we should go to what? B2, isn't it?
Yes, B2, which
Yeah.
is A level, yes, standard.
And now they are talking
And,
about
and mind you, Brakoku, let's
Mhm.
give context to this.
Right.
Because B2 before was for naturalization applications. Even naturalization is B1,
Mm-hmm.
you see. And now they are saying that settlement will be B2. So they are moving it up by one point. But again, B2 is equivalent to A level. What about those people who cannot really read and write? Then they will not benefit at all. But so if somebody is asked, what do you think about this? They have to be able to explain that, much as it is good for people to understand the language and be able to participate in the communication activities in the UK, saying that somebody should be speaking at A-level standard is extreme. At best, we have to leave it at, let's say, B1. Then that is how people can participate in this conversation.
Okay. Then this one is saying, how do you think integration should be assessed? Through a formal test that is live in the UK, through gathered ongoing evidence, all that, through completing a cultural orientation course once arrived in the UK. Now they are asking us, do you want to write a live in the UK test? I think exactly that's what they are asking us. So
And here, because you see, most people within the community will be wondering, how do we even do the answer the questions in the first place? So what you are doing is really good. Already there is life in the UK test, isn't it?
yes.
Why don't we leave it like that for most people? And those who cannot genuinely, maybe we find an alternative for them. Maybe something they have to attend a course or something. Then there will be evidence that yes, they can do. They can have an appreciation. Because at the moment, what we have is that do the exam or bring evidence that you can't do the exam.
Yeah.
If it's going to be compulsory, because life in the UK has not been touched, but English has been touched.
Yeah.
It will get to a point where they may even come back and say that it's compulsory, whether you are sick or not, you have to do the exam. And that's quite punitive.
Yeah. Okay. So we move on to do you have okay, then it gives you the options. Do you have any further comments on how integration should be considered? Yes, I have a further comment, but how do I, in Tibro 4, I can't write so very well. How do I do that? Okay, let's go to the contribution. Do you think that following groups should be exempt from the requirement to have earned above 12,750 for at least 3 to 5 years? Lawyer was explaining that 12,750, it says above. And even the above, now you have about 38,000 to even end. So you reach the threshold that you can reduce the amount of whatever. So those are maternity leave, and the other details should not be included. Are there any other groups? You can say, okay, I am in this group, I'm in that group. We'll get to that. To what extent do you agree or disagree that migrants who have worked in an occupation below RQF, that is the 12,750 level 6, should have their standard qualifying period for settlement set at 15 years? That's a long one. Occupation skilled to RQF level are those which require qualification equivalent to degree level or higher. You can read about that. So that question, do you agree? Do you disagree? Do you strongly disagree? Are you in the middle? You don't know whether to agree or disagree. To what extent do you agree or disagree that applicants who earn a taxable income of above 50,270 should be eligible for a reduction in their time of settlement? I agree. That's up to you as well. What do you think about the proposed reductions for applicants based on their annual taxable income? And lawyers was explaining that. So, yes, if you don't agree, yes, you'd say that. But I would want us all to take our time and go through this. Sometimes we think that we can take it off. Sometimes we think that we're not lettered enough. We haven't gone to school and don't understand English too much. You realize from the very beginning, it says that you can do it as an organization or as an individual. But I guess associations can organize so that they take people through this as we are doing as a community service, can't we?
Yes, we have community-based groups, youth groups, churches. So even within the church, there can be a workshop where everybody will open their phone, and then somebody will be showing them how this should be answered. So that it's not one person answering it. Everybody is answering it, but with an understanding and clarity.
Okay.
So that the whole day or the whole hour, that is what everybody is doing up to the end of the questions. Then if you need support, they support you. Even though it's supposed to be individual, but it also has to be. There's a reason why it says whether organization, because there are some organizations, what we call the crusaders or social activists. Those activists championing immigrants, welfare, and all those things, they're all going to be doing this. So they want to know whether it's coming from individuals or organizations. So if you're a church, the church can do it, but members within the church or the groups can do it as well, but somebody can be helping, explaining to them as we are doing today.
Okay. All right. So I believe that we, as lawyer said, he's offered to give us extra time to get through some of the questions and all the answers. I don't know whether our friend is still on the line. If not, we will have to call the person back. But I have one from Fizzy James, who is saying that if a migrant should spend 3 years on a student visa and 2 years on a graduate visa with volunteering, can I get indefinite leave to remain in 5 or 7 years? Lawyer.
So he's saying that 3 years student, 2 years graduate, right? But already graduate visas don't count towards settlement. So that is minus, is 0 there. So it's actually the person just talking about the student threshold, 3 years.
Okay.
Yeah, so there's no 5 years here. You haven't done 5 years because the 2 years post-study visa doesn't count.
Okay. I understand the person who called has hung up, but please, if you can, call back, and I think we have your number. We can call you back if you so wish. Aquinas says, so the low tax rate earners earn less than 12,750. That's somebody seeking some clarification, lawyer.
Okay, yes. So the 12,570 is what we call personal allowance. Those people don't pay tax at all. It's tax free.
Okay.
So if you earn up to 12,570, you are 0 tax payer.
And your contribution is minimal, isn't it?
Your contribution is 0 in terms of finance. So that means you have to contribute in other kind.
And volunteering would come handy for
that's the volunteerism. Yeah, volunteerism is what I call contribution in kind. So there's monetary contribution, which is the tax, and kind contribution. I want us to contextualize this and make it as practical and down basic as possible. That's why I'm not using the jargons. So if you don't earn enough and you can't pay more tax, use your energy, use your wisdom, use your hands, use your legs, use everything you have to help the community. That's contribution in kind.
Okay. All right. Thank you. We have Eunice. Okay, let's go to Mohammed one. How many years will someone take to earn 29,000? Or someone who is earning 29,000, how many years would they get? 29,000.
29,000. Okay, so let's do the maths. 29,000. If you take 12,570 from 29, let's put it into absolute terms. Let's say it's 13,000. 13,000 from 29,000 gives us 7. Gives us what? 16, right? 16. Then add the 430. So it's 16,430. 16,430, you are basic taxpayer. You are paying tax of 20%. 20 times 16, 16 times 2 is 32. So you are paying 3,200 a year. That is not enough to score points for settlement.
Okay, all right, Mohammed, thank you. I think we have one from Eunice J. Yes. If a skilled worker on care visa has an annual salary of 53,000 over a year, would they be qualified for 5 years, lawyer?
So skilled worker, again, we are looking at contribution in cash or finance, because the question is about the money. Let's do the maths. We take 13,000 from 53,000, it gives us 40,000, right?
Yeah.
So 40,430 is how much the person is paying tax on. If it's 40, 40 times 2, 428. So that is 8,000 a year. 8,000 a year, maybe because that is why the rules say that those in the upper, the mid range is 50,270. Yours is 53. And so you are paying tax on 40%. 40,000 is a high tax and rate and earner. And so if you are paying 8,000 a year for 3 years, you shorten it to 5 years.
Okay. So yeah, Eunice, thank you. I have Nana Nyako Boating. So sorry if this question has been answered already, but no, that part. Do mortgages, credit card, and loans form part of the debt we are talking about, which you're already paying in bits? Would it be part of the debts that we'll be looking at?
So when we say debt, we are looking at risks associated with or to that debt. If you have a mortgage and you are paying, that is arranged debt, isn't it?
Okay.
But if you take a loan and you abscond, that is risked debt. And those people who have left footprint on debt records, banks, NHS, HMRC, and so on and so forth, will have punishment when it gets to indefinite. So that's what they mean by debt. So mortgage, if you are paying your mortgage, that is not debt. That is a loan. You are everybody takes loan anyway. Most people take loans.
I think our friend Nana is worried about credit cards as well. So if you pay your credit card regularly, then it's safe, isn't it?
So credit card again, whose credit card are we looking at? We are looking at somebody who has taken credit card and has changed the name. The bank is not even responding. That is absconding.
Okay.
Yeah, so that is proper debt. But if you have credit card, you use and pay. That is arranged debt.
Okay. All right. So yeah, Nananya saying you shouldn't worry about that. We have Mame Inda Bozo. How much does it cost on parent visa application, NHS fees, and immigration?
What visa is it, please?
Mami, if you could come back and give us some clarification.
No. It says, how much does it?
It says parent visa application. Yeah.
Parent, right. So potentially 2.5 as a parent of a British child or a qualifying child. So that is 3,910, including IHS. The visa fee is 1,321, and the IHS fee is £2,587.50.
Okay. Right, Mami, thank you for that. We have had yours covered. We have Nana Dineho. My partner is a care worker and I'm a prison officer. My salary is above the minimum threshold. Will both salaries be considered for a 5-year indefinite leave to remain application, as my salary is above 40,000?
I'm not sure whether Nana is talking about contribution-based approach the government has introduced, or is talking about the standard 29,000 that you need to have to apply for. If it's not about the standard 29, but it's about whether my salary and my wife's or spouse salary will be combined to determine the threshold. No, it's the person who is making the indefinite leave to remain application whose salary will be considered. And it's not just about the salary at the time of making the application. It is the 3-year consecutive contribution to tax that will be looked at. So if last year your salary was normal, last 2 years was normal, but the last 3 years it was good, or it was normal, and now it's even 150,000, then you are going to start this year, isn't it, in terms of high contribution?
Yeah.
Because it says 3 years. So we have to check the 3 years. But again, it's individual, not combined.
Okay. Well, we're moving on. We're soldiering on. We're still live on the Community and the Law brought to you by BWF Solicitors, and we're live on BWTV UK. We're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. Lawyer, thank you for your help. My name is Mr. C.O. My wife is extending her first 2 years, 8 months stay in the UK as a spouse through her husband as a settled person. On the online forums, there are questions about her husband, kids, and she should confirm she will be providing evidence of their relationship. Meanwhile, the child lives with her mother and she doesn't have any relationship with the child or play any role in her upbringing at the moment. If she didn't confirm it, she can't continue the application. So can she confirm it and explain why she doesn't have the evidence or she is filling the wrong form?
Well, I don't know the form the person is filling, so I cannot comment on the form. Let's stick to the substance. The substance is that there is a question which is controversial. What does it mean? When they say, do you have children who are not applying with you? They are referring to your children, whether abroad or in the UK. When they ask you, does your partner or sponsor have children? You say yes. Sometimes they will even ask you, do you have dependents who are not applying? If you or your sponsor have dependents, in other words, other children who are not applying, you have to indicate. So you say yes. Then they'll say, will you provide evidence? That one is a standard thing. If you don't say yes, you can't continue. So you say yes. But when you get to the document stage, when you are collating the document, normally once you mention children, you have to provide the birth certificates and where the children are. If the children are living in the UK, you have to indicate where the children are. But this is somebody, I'm sure, living with the spouse or the sponsor. So if the children are for either of them, unless the sponsor is somebody that has remarried and is applying and helping this individual, this is a spouse. So it depends on this the status of this spouse. Let's assume that the person remarried, and so their children belong to some other parent. Then that step parent in here will have to indicate those stepchildren. But if the parents are for both, if the parents, both parents are for the children, then it's straightforward. So please say that our friend who brought this question will need further and better explanation after he has clarified the context of the application they are doing.
Okay, right. So my dear friend, if you can, please help us with some further and better particulars. Please, I'm a skilled worker on salary of 24,977 as on my contract, but at the end of the year, I earned 48,000. Am I going to be on the 5-year or 10-year route? Or 5-year or 10 years. I think that's what the person would say. Again, I'm a registered midwife yet to get a job offer as a midwife. Can you explain where I will be on the new visa rules? Anyway, let me also stress again before lawyer comes in. These are proposals. They haven't become the law yet. That's why you would need to go through the consultation document and make your sentiments, your feelings, your understanding, and your ideas known. So I would plead with everybody. Parisa, if you could put the link back on, we'll come back to Nana Kusia Japoman's thing, but put the link back on for people to pick up. If you can't write it quickly, you can screenshot and then make sure you complete the consultation. It will be on and open until the I think February 2026. They are hoping to bring this into being and into effect in April 2026. We have the chance to express our views on it. We could do that as individuals, we could do that as associations, we could do that as organizations. So go to ukhomeoffice.qualtrics.com and you can find the form. The rest sometimes will confuse you. But if you go to the Home Office website, you can find the consultation document, Home Office consultation document on new immigration proposals. And please, at least start from pages, I think 30 or thereabout, and go to the end and complete it. If you have issues with how to complete it, get somebody to support you, or you can get in touch with us and we'll help you go through that. Now, let's come back to Nanaja Poman's question. I'm a skilled worker on salary of 24,937 as on my contract, but at the end of the year, I earn 48,000 pounds. Am I going to be having my indefinite in 5 years or 7 years or 10 years? Again, I'm a registered midwife, yet to get a job offer as a midwife. Can you explain where I would be on the new visa rules if they come to effect? Lawyer.
Right. So let's start from the second part. If the person finds a midwifery role in the health sector with NHS, then that will be part of public services. That will give points. But in terms of salary, remember the salary says that above 12,570, which is the case. It's above, because it's 48,000. However, it tells what above means. It says above means 50,270 or 125,140 is the persons above within the prescribed above. No, it's below the prescribed above, isn't it? Yeah, so there wouldn't be enough points.
Okay, all right, Nanaja Poma, well, that's the answer to your question. Let's take a few more. I'm on a 10-year route as a parent of a British child, and I've just submitted my 4th extension application. Will this have any impact on my situation? You've submitted your 4th, so obviously, plus or minus, there will be a decision before April 2026, isn't it? Lawyer, I guess I'm thinking right.
Well, we can't really tell when the decision will come. This proposal is going to affect all those who are not yet British, who are not yet settled, who have not received their indefinite leave to remain yet. This person is going to the fort before they go for indefinite. So even if the fort comes before April next year, they will still wait for the last 2.5 to be over before they attempt indefinite. So definitely, they are going to be affected by the proposal. Especially when they are receiving benefit, it even be worse.
Okay, so then I would please urge everyone, the issue about transitional provisions. People are saying that, well, why can't it take effect beyond April? And those who are within already, that's why you should complete the survey, because then you have or be given the opportunity to express your opinion whether transitional provisions should happen, because this does not really state that. Citizen Kwajo, okay, Gomez says, I work as a carer and earn 50,000 a year.
Right. So the person earns
okay,
as a
I
carer.
think it's some further explanation to that, further details to that. Yeah.
Yeah. So if it's 50,000, so Gomez, what I would say is that keep working hard so that you can earn more. Because the rules say that 50,270, you are earning 50,000, which is below 50,270. If you can get about £500 to get 50,500, then you can shorten your time by what is described, which is about 5 years.
Okay. Citizen, yes. Let me look at yours as well. Previously overstayed his visa, but his stay was later regularized through the family route, and he was placed on the 10-year route as a consequence of the overstay. Since then, he's complied with all the requirements and obligations under the law. One, why should this new law affect Kofi and other rules, especially skilled workers, when it seems unfair onto us? Can this be challenged on the grounds of deception, extortion, or any related reasons? If Kofi gets married to my partner, would that allow me to switch to the 5-year route, even though I have around 2.5 left before reaching settlement on the current 10-year route? Lawyer.
I mean, Kofi is expressing sentiment. This sentiment should not be expressed on this platform. It has to be expressed through the survey. So, Kofi, if you have a lot to say it in the survey. On the second part, where you said that, can I switch? What did he say, please?
It says if Kofi gets married to a partner without allow him to switch to the 5-year route, even though I have around 2.5 left before reaching settlement of the current 10-year route.
Yeah, but if you are going to get married and to start another 5-year route, you're only going to save 2.5 because you still have to do the 5 years under the new partner visa. What you can do, since you are yet to get to the end of your default journey. See, I've couched my words carefully. I didn't say end of your time. I said default time. The default time was the standard 10 years, which is going to change to about whenever, depending on when you enter the UK. In this case, what you can do is to volunteer more so that you can get a discount of about 5-7 years, depending on how much you volunteer. And if you are working and earning, all this will come together so that at least by 10 years, you'll be able to apply for your indefinite leave to remain. But changing alone will not really make any difference, especially if you are applying for another 2.5 as a partner per se.
Okay. Well, keep them coming through. We've got a few more moments to go. Remember, we'll be doing our quiz as well. My sister and her family want to stay in the UK after charity visa expires. Please suggest the visa she can switch on to for her and the family to stay. Lawyer.
Well, there's no visa for this person. Once the visa has expired, you are an overstayer. The best case would be that the person was in the UK, but here they are in the UK as husband and wife, right?
Mm-hmm.
Yeah, you say my sister and her family. I don't know whether the family are children, the partner, who are those family. Let's assume it's a family of children and partner. Then you cannot even go into different pathways because it will affect the rest. So you may have to go back and re-enter on different category. Because charity visas, not all of them are switchable.
Well, Chevy Max, we go to Kwajo for he's expressing a sentiment. But Kwajo, I would ask you to go ahead and complete the survey as well, and ask other people to do it, as many as we can do it. Remember, I think there was one situation that it should serve as a lesson for all of us. You remember when Brexit and some of the proposals were put out and the consultation was happening? We were asked to go in and express our opinions. We didn't do. And when things came back to haunt us, we're like, oh, I remember Uncle Ben and all the rest of the lawyers were talking about this profusely. People don't do it. Kojo, I beg you, go and complete the survey and urge people to do that so we can express what these things are to us, to them, so they can make changes or probably even listen to what we will want to say. Those proposals are turning points in the life of migrants in the UK. Kojo, yes, it is really turning points, as you have mentioned. Any other? I hope our friend that called earlier on would call back. If not, well, we take a few more and draw the curtains down. I had a British child, but when I applied for her passport, they denied. But I had divorced my old husband. Is there anything we can do, because we went for interview and was a bit intimidating? Is there something we can do, lawyer?
I mean, normally they will ask you to attend interview. Whether it was intimidating or not intimidating, they were not satisfied that the child belongs to the British citizen, under whose right the child is making application for citizenship under Section 1 of the Nationality Act of 1981, automatic citizenship. So if you want to try again, put in another application for passport and let's see. But if they come back for interview with interview request, then again, you have to go for the interview. So it is what it is. So if you want to give us a ring, let's discuss in detail and see.
Yes, so you can call BWF Solicitors on 028-493-7340, 077-127-61884, or you can call Lawyer Charles Asma himself on 07947603037. Sandra is asking, can someone with a tourist visa switch to a student visa? Lawyer?
No.
Okay. Tourist visa more or less is a visitor's visa, isn't it?
Yeah, that's visitor's visa.
Okay. We'll take the very last one and then we'll move on to pick up our nugget quiz question and get the answer and then do a summary for the day. Good evening, lawyer. I have a child with 2.5. As a father, I don't have. Can I stand on my child to do my application? Your question is not too clear, Irene, but I assume you are trying to say that you have a child who has 2.5 and you are the father and you want to depend on that child to make an application. Lawyer.
I mean, technically, the child does not fall under Section 117D of the NIA Act of 2002, in that this child is not a qualifying child. A qualifying child is a child who is a British citizen, or a child with indefinite leave to remain, or a child who is an EU national with pre-settled status, or a child who has lived in the UK for 7 years and born in the UK. This child has 2.5. What it means is that the child was not born in the UK, the child is not a British citizen. Even if the child was born in the UK, it's not a British citizen. That is why they applied for 2.5 for the child through somebody. And so the only option left is not within the rules, but outside the rules. Outside the rules means that under the immigration rules, there's provision for considerations outside the rules. So the person doesn't meet the rule, but can the application be considered? Because if the person is asked to leave the UK, it will affect the child who is not a British citizen. Then that could be an approach for this person to make an application and that's on this basis.
Okay, so yeah, thank you very much, Asma. Thank you all those who've been there and been contributing, those who have followed, and the rest of it. Please, let's go to the consultation document and complete it. Complete the survey. Please complete the survey. Please complete the survey. And I'll say again, please complete the survey. If you have challenges, get somebody to help you do it. But as many people as possible, please complete it. Now, from the 1st of May, 2026, it will be an offense for a landlord or a letting agent not to allow an individual to enter into a tenancy agreement because the person claims benefit. Well, there's somebody on the line now. Let's quickly pick that one up. Then I'll come up with my scenario and the quiz question. Hello.
Indefinite leave in April. I was saying a British passport.
Okay, last this person, yeah, do more radio, no mommy. Do more computer, laptop, iPad, whatever. Do no mommy. Can you hear me? What's in car phone also?
Hello.
Can you turn the volume of your set down and listen to us on the phone, please? You see, you can hear yourself because there's a delay. So, do set, no do laptop, no do computer, no do TV, no TV or phone also, please. Oh, sorry. You can call back when we are finished with the program and we'll get some answer for you. So okay. Let's go.
Let's answer the question. I think we had the bit of it. So this person is saying, I got my indefinite in April. Let's say April 2025. When do I apply for naturalization? Is that not a question? in a way. I was going to ask the person to confirm how the person got the indefinite. If the person got the indefinite as a spouse of a British citizen, then the person is already due for naturalization. For those people, they don't wait for 1 year. Apart from that, you have to wait for 1 year. That's it. So British spouses who have had their indefinite, the next day they can apply for citizenship. If you are not, then you have to wait for 1 year.
Okay. All right. Citizen Kwadjo comes up with something. I'll read that at the end of it. I'll read that as part of my sign off. Don't worry, Citizen Kwadjo. I share your sentiment. So yes, we mentioned that from the 1st of May 2026, it will be an offense for a landlord or letting agent not to allow an individual to enter into tenancy agreement before because the person claims benefit. We talked about the Renters' Rights Act of 2025. So then a friend came to ask us a question, and Cecilia, she says that she lives with her 2 children. Her current tenancy expires in June 2026. Just recently, she has had access to public funds and she received £2,400 per calendar month. Her landlord had assured her previously that, listen, when we get to 2026 June, I'm going to allow you to renew the tenancy because I see you as a good tenant. But then the landlord found out that, Cecilia is receiving public funds, so I'm not going to allow it. She's not worried. Because if the landlord says, nah, I'm not going to allow you, then June 2026, she might become homeless. So let's advise Cecilia. Are you going to say Cecilia should start looking for alternative property to rent because she has no option? Are you going to say Cecilia should beg the landlord to allow her to continue the tenancy agreement in June 2026? Otherwise, she may be homeless. Are you going to say Cecilia should not worry about what the landlord is saying because being on benefit cannot be an excuse for the landlord not to renew the tenancy for her? Keep them coming through. I'm going to just drop our social media handles, and when we come back, we'll pick your answers. Already Nana Sante says it's number 3, but take note of my social media handles. Okay, so you've taken note of our social media handles. We're on Facebook, LinkedIn, YouTube, and every one of them you can think of at BWF Solicitors. So yes, what would you say to Cecilia? Let's quickly pick up your answers and see whether we were able to follow. Nana Sante says, number 3, yes, Cecilia should not worry at all. Next, we have Elizabeth Jedu. Yes, Cecilia should not worry. Number 3, thank you. Ajua Dujemfi, Cecilia should not worry. Number 3, thank you. Kwabena Drew, Cecilia should start looking for alternative property to rent because she has no option. Anita Usu also thinks it's number 3. Thank you, Anita. Thank you for contributing. Koko Drew, Cecilia should start looking for alternative property. You say it's number 1. Next, we have Yabwa J. Cecilia should beg the landlord to allow her to continue the tenancy agreement in June 2026. Benedicta Frimpong says it's number 3. Thank you, Benny. Andrew Osei says it's number 3. We go to Abna Boating, number 1. And I'll take the last one. Selena Yabua says it's number 3. Lawyer, which one of them? is the best answer. Konyotu 4, you've sneaked in. It's number 3. Okay, let's see. Tilly Duma also says it's number 3. I'm not taking any more answers because it's time for lawyer to tell us what it is. Lawyer.
Right. So this time we are going to give to those who are preparing for their legal accreditation. So we are going to represent all those preparing for their legal accreditation. So let's speak for them.
Okay, now the Renters Act of 2025 says that from the 1st of May 2026, it will be an offense for a landlord or letting agent not to allow an individual to enter into a tenancy agreement because the person claims benefit. Now, what is the story of our dear lady? Cecilia is saying that, yes, the assurance was that in June 2026, she was going to renew the tenancy agreement. But the landlord also just said that, no. I just heard that you are now claiming benefit. So I'm not going to allow you. Cecilia, don't worry. The landlord cannot say that because of that, you cannot renew your tenancy agreement. So for me, it's number 3.
And what's your authority?
The Renters' Right Act of 2025.
Which specific provision?
Section 34(1)A IV of the Renters Act, Renters' Right Act of 2025. Oh, lawyer, in the Marco School.
Please, tomorrow you are needed at the Law Society for your legal accreditation so that you can start practicing. If passed.
Thank you very much.
You have proficiency of the Renters' Right Act, so you can now be advising on rent and tenancy and tenants' rights.
But I am also careful that I'm doing this on the platform provided by BWF Solicitors. So I am giving this answer on the wings and on the authority of BWF Solicitors, not on my own. So
and the caveat is only valid for immigration advice purposes. And this is not immigration advice. This is rent advice.
Okay. Thank you very much.
You don't fall foul of the law of the Section 91 of the Immigration Act of 1971 at all, because this is not immigration advice.
Okay. So I'm minded to be careful when I'm giving immigration advice.
I agree. Okay.
Right, thank you for clapping for me. Yeah, I've done well.
Right.
Well, at this point, we go to tradition and ask our lawyer to give us a brief summary of what we have looked at today. We've looked at the new UK government proposals on immigration and how it affects us. Lawyer.
Right. So the nutshell is that the government is dreaming. We're not sure whether the dream will become a reality or not. Whether it will or not depends on whether we support the dream or we don't support the dream. How do we not or support the dream? Go online, follow the link, and participate in the consultation. Make your voice known that this is harsh and draconian for most people, so that something can be done about it before it becomes law in April. Otherwise, what will happen is that for those who are waiting for 10 years to settle, will wait for 15, 20, 30 years. Those who are waiting for 5 years to settle will have to wait for 10, 15 years. Those who are waiting 3 years to settle, they have to even do more in terms of tax and other contributions. In all this, there are winners and losers, but the losers are more than the winners. So let's all get involved and participate in the consultation, which will end in February 2026. A stitch in time will save us 9 stitches.
Well, thank you very much, Lawyer Charles Asma. Mame Indabozo, if you actually want to have further explanation and support, please call BWF Solicitors 0208 493 7340. Or you can call the emergency number 0771276184. Thank you very much, Lawyer Charles Asma. Thank you very much for your time and even giving us an extra half an hour, and also making sure that you have empowered us. And I believe that on behalf of my numerous viewers, listeners, and clients and friends, we're going to heed to your advice and go over to complete the survey. It's open until February 2026. So let us all go on and do it. Thank you, Loyasma. Thank you, BWF Solicitors. But I'll end with this one from Citizen Kwejo. It says, Brakweku and BWF use this big platform, help educate us more on how we can express our thoughts, and if our thoughts can help change this new upcoming law. You rightly say so, Brakweku. Thank you very much, Citizen Kwejo. Yes, I rightly say so. It will help shape the law. It will help us go through things. It will help us understand what it is that we need to understand. And of course, it will help us influence what the decision should be. It's been the community and the law. My producer has been Professor Ade, supported by Shilankra and Padmo Dodu. My name, once again, Husu Frippon. Have a good evening. We'll meet again, same time next week.